Today, we're diving into a huge question. How is China actually defining data ownership? And the answer is pretty surprising. It's not happening through big, sweeping laws from the top, but from the ground up, inside its courtrooms.
So think about it for a second. All that time you spend on your screen, every scroll, every click, every time you shop online, you're creating this massive, valuable trail of data. But who actually gets to own it? Is it you, the platform you're using? In most places, the answer to that is still really fuzzy.
But in China, this fundamental question of our digital age is getting answered in a very different kind of place, the courtroom. Yeah, that's right. Instead of waiting around for lawmakers to write the rulebook, judges are being thrown into the deep end, forced to draw the map as they go.
To really get why, you gotta picture China's digital economy as a kind of modern-day gold rush. It just exploded so fast that it created this digital Wild West, a huge, incredibly valuable new frontier with almost no laws to govern it.
The big issue here is a massive legal gap. Sure, there are some existing laws, but they're just way too abstract to handle the kinds of messy data fights that happen between tech giants. And the administrative rules, well, they're mostly for show. So what happens when a real conflict erupts? Everyone turns to the courts, which basically forces judges to become innovators.
And that brings us to the first really key players in this whole story, the trailblazers. These are the local courts, right in the heart of China's tech hubs, who are dealing with these disputes every single day and coming up with practical solutions on the ground.
They're using a method that's been called judicial continuity discourse. The analogy here is perfect. Think of these judges as skilled mechanics who are suddenly asked to fix a flying car. The manual for it hasn't been written yet. So what do? They cleverly adapt the tools they already have, in this case, intellectual property law, to solve these brand new, futuristic problems.
Now, this isn't just some abstract theory. We can see exactly how this works by looking at a huge landmark case, Taobao, which is owned by Alibaba, versus a smaller company called Meijing.
What happened next was like a conveyor belt of justice. The case moved up through 3 different levels of courts, and each one added a really crucial piece to the puzzle. First, the special internet court made a key distinction between raw user info and the valuable data products Taobao was creating from it. Then, the next court up refined that idea, clarifying the property interests, and finally, the High Court added something called the creative labor theory to decide if real intellectual work went into it. So each court literally built on the last one, creating a whole new legal standard right from scratch.
Okay, but that's only half the story. Because while you've got these trailblazers on the ground, you also have the architects from above. We're talking about China's Supreme People's Court, and they are looking at the much bigger picture.
The Supreme Court uses a totally different approach, judicial linkage discourse. So, if the local judges are the mechanics fixing one car at a time, the Supreme Court is the city planner. They're not just focused on one problem. They're making sure that every single new legal decision fits into the nation's grand master blueprint for its digital economy.
And you can actually see this shift just by looking at the language in official documents. Back in 2008, a national policy flat out told the courts to play the leading role. But fast forward to 2021, and that direct, explicit phrase is gone. Now, this doesn't mean the courts lost power, not at all. It just suggests their role has become more subtle, more about guiding and aligning with national policy instead of leading the charge all on their own.
So you've got these 2 different approaches, right? You have bottom-up innovation from the local courts and top-down guidance from the Supreme Court. You'd think they might clash, but what's so fascinating is that they actually work together in this incredibly dynamic system.
The academic name for this system is Bidirectional Conceptual Coupling. I know, it's a mouthful. Let's just call it BCC. But don't let the complicated name fool you, because the idea is actually simple and super powerful. It's basically a continuous feedback loop where the trailblazers and the architects are constantly shaping and legitimizing each other's work.
So here's how this dance works. First, you have an inside-out flow. Those successful innovations from local courts, like the one from the Taobao case, they get sent upward. Then you get an outside-in flow. The Supreme Court takes those broad national goals and translates them into guiding principles that then flow back downward. It's this constant, adaptive process.
So why does any of this matter? Well, because this unique system is essentially a real-time experiment in how to write the rulebook for the digital economy. And that has huge implications, not just for China, but for everyone.
At its core, this whole thing is a high-stakes balancing act.
The courts have to navigate these competing goals. On one hand, they need to create unified standards for the market, but on the other, they have to stop giant platforms from becoming monopolies. They need to protect data as a form of property, but without stifling the very innovation that the digital world depends on. It's a tough tightrope to walk.
Chanho Liu, the author of the research this is based on, just sums it up perfectly. He says this approach isn't just about making up rules on the fly. It's about finding that delicate, crucial balance between creating stable market standards and, at the same time, making sure that the most powerful tech companies don't get to write those rules themselves.
And you've got to understand, this is not just some interesting academic theory. This process, this feedback loop we've been talking about, is directly influencing and actually shaping the laws that are going to govern China's digital future.
Just look at the upcoming changes to the anti-unfair competition law. The new Article 13 directly stops platforms from using their data to shut down rivals. It frames data in that exact dual way we were just talking about, as something that needs protection, but also as a tool that can be used unfairly. These are ideas that were hammered out in courtrooms, in cases just like Taobao v. Meijing, and now they're being written into the law books.
So, what's the big takeaway here? At the end of the day, China is building the entire legal infrastructure for the digital age. The roads, the bridges, the power grid, not from some single top-down master plan, but in real time, piece by piece, and courtroom by courtroom.
And that leaves us with one last really big question to chew on. In a world where technology moves so fast, way faster than any government can keep up, is this kind of adaptive, bottom-up, judge-led system maybe the future of how we make laws for the digital age everywhere? It's definitely something to think about.